Welcome, my brothers. Strength and powers. And we continue Trust and Trustees, Encyclopedia Britannica, 11th edition, 1910. Trusts. A trust in English law is defined in Lewin's Law of Trusts, adopting Cook's definition of a use as, and I quote, a confidence reposed in some other, not issuing out of the land, but as a thing collateral annexed in privity to the estate of the land and to the person touching the land, for which Seteki Trust has no remedy but by subpoena in chancery. End quote. The term trust or trust estate is also used to denote the beneficial interests of the Seteki Trust. The term truster is not used as it is in Scotland to denote the creator of the trust. So truster, truster, is used in Scotland, but it's not used in the definition there to denote the creator of a trust. So we learn the definition of Seteki Trust, and let's go and check out the definition of subpoena. So trustee Duddy handy black so 8. Subpoena, Latin, under penalty, a writ commanding a person to appear before a court or other tribunal subject to the penalty for failing to comply. A writ commanding a person to appear before a court or other tribunal subject to a penalty for failing to comply. Also spelled subpoena. Cases, witnesses, corpus juris secundum, witnesses, section 20 to 22, 25, public law, subpoenas. All right? So that's what a subpoena is. So a subpoena is a writ. So that comes from the court of chancery as we saw here. By subpoena in chancery. All right. A trust has some features in common with contracts. So a trust has some features in common with contract. But the great difference between them is that a contract can only be enforced by a party or one in the possession of a party to it, while a trust can be and generally is enforced by one not a party to its creation. It has more resemblance to fidei commissum. All right, remember we look at the definition of fidei commissum. But the latter could only be created by a testamentary instrument, whilst a trust can be created either by will or inter vivos. Inter vivos is among the living while you're alive. Nor was there any trace in Roman law of that permanent legal relation which is suggested by the position of trustee and Seteki trust. The heir, too, in Roman law was entitled from AD 70 to the reign of Justinian to 1/4 of a hereditas fidei commissaria as against the beneficiary. So let's see what hereditas fidei commissaria is. Hereditas. So, all right, so let's check out heir. Heir, a person who, under the laws of intestacy, is entitled to receive an intestate decedent's property. Ancestor. So we're looking for hereditas. H-E-R-E. H-E-R-E-D-I, hereditament. So let's read what an hereditament is. Because all these are words you come across. Hereditament. Sense one. Any property that can be inherited. Anything that passes by intestacy. That's an hereditament. Let's see if we can find hereditas. Okay, so hereditas. Hereditas. Latin 1. Roman law. An inheritance by universal succession to a decedent. This succession applied whether the decedent died testate or intestate. So, testate is when you die and you left a will, and intestate is when you die and you did not leave a will. You did not leave any instructions on what to do with your property. And whether in trust, ex fide commisso, for another or not. The comparable right under Praetorian law was bonorum possessio, possession of an inheritance that could be the basis of a right to succeed. Right? Hereditas, hereditas. Right? So that's hereditas. Right? So hereditas is an inheritance by universal succession to a decedent. So hereditas, a universal inheritance. Fidei commissaria. Let's see if we find. All right. Fides, fidelity. So let's get it. Make sure I have this correct spelling. Fidei. All right. Fidei commissum. So fidei commissum is a direction to an heir asking the heir as a matter of good faith to give some part of the inheritance, such as a particular object, or all the inheritance to a third party. Right? And in a will, and sometimes in a will, you see the testator will say, all right, so we leave the house to this one, and we leave the bank account to this one, we leave the car to this one, we leave the jewelries to this one. Yeah, fidei commissum, right? All right, see if we find fidei commissarius. Fidei commissari. Fidei commissari us. Fidei commisso. Okay. Fidei commissaria. Sarius. Setekitros. So a fidei commissarius see setekitros. A setekitros, remember, is a beneficiary. So a fidei commissarius is a beneficiary. Fidei commissari see setekitros. So it falls under beneficiary as well. Fideis. Fidei commisso. Committee. Alright. Alright. So also so fidei commissaria, sometimes what happens is the spelling is changed in the pronunciation in the modern dictionaries, right? So fidei commissarias, fidei commissarius, seems like all of them fall within the Seteki Trust, which is our beneficiary. So hereditas fidei commissaria as against the beneficiary. So while the very essence of the trust is its gratuitous character, trust may be divided in more than one way, according to the ground taken as the basis of division. One division, and perhaps the oldest, as it rests on the authority of Bacon, is into simple and special. The first being where the trust is simply vested in a trustee and the nature of the trust left to construction of law. In modern times, the simple trust is considered if it's just vested in a trustee, is considered a passive trust, meaning that the trustee doesn't really have any duties to perform. The second, where there is an act to be performed by the trustee. So that's active trust, where the special trust in modern times now is considered an active trust, where the trustee has some duty to perform. Another division is into lawful and unlawful and corresponds to Bacon's division into intents or confidences and frauds, covens or collisions. A third division is into public and private. Well, public is like charitable trust and statutory trust. Other trusts like that, Tontine trust and different trusts like that. A division often adopted in modern textbooks and recognized by Parliament in the Trustee Act of 1850 is into expressed, implied, and constructive. So an express trust is determined by the person creating it. It may be either executed or executory. So let's run and look at the definition of executed and executory. So executed, execution, executed trust. Executed trust, executed. Executed. Sense one, of a document that has been signed and executed will. Sense two, that has been done, given, or performed. Executed consideration. So an express trust may be executed, that has been signed, and so it has been signed. The document has been signed. There's nothing else to be done. It has been signed and given. Let's look at executory. Executory. 1. Taking full effect at a future time. Executory judgment. To be performed at a future time, yet to be completed. All right? So executed, signed and done. Executory, to be performed at a future time. So it may be, so an express trust is determined by the person creating it. It may be either executed, signed and done, or executory, to be performed at a future time. The former, where the limitations of the equitable interests are complete and final. The latter, where such limitations are intended to serve merely as minutes for perfecting the settlement at some future period, as in the case of marriage articles drawn up as a basis of a marriage settlement to be in conformity with them. An implied trust is founded upon the intention of the person creating it. Examples of it are a resulting trust, a precatory trust, and the trust held by the vendor on behalf of the purchaser of an estate after contract and before conveyance. In this case, the vendor, sometimes called a trustee, sub modo, let's see what sub modo means. Sub modo. Sub modo. Sub modo. Sub modo. Sub modo. Latin. Subject to conditions or qualifications. The riparian landowner enjoys the property sub modo, that is, subject to the right of the public to reserve enough space for levees, public roads, and the like. Sub modo, subject to conditions or qualifications. All right. So where it says here, in this case, the vendor is sometimes called a trustee sub modo, subject to conditions, and the purchaser is seteki trust sub modo, which is a beneficiary subject to conditions. A constructive trust is judicially created from a consideration of a person's conduct in order to satisfy the demands of justice without reference to intention. That's a constructive trust. The distinction between an implied and constructive trust is not always very consistently maintained. Thus, the position of a vendor towards a purchaser after contract is sometimes called a constructive trust. The present law governing trusts rests upon the doctrines of equity as altered by legislation. The law was consolidated by the Trustees Act 1893 and some subsequent amending statutes. Its great importance has led to its becoming one of the most highly developed departments of equity. Right? Who may be a trustee or seteki trust? So who may be a trustee or seteki trust beneficiary? The modern trust is considerably more extensive in its operation than the ancient use. Thus, the crown, so when you see crown, think state, right? So anywhere you see the state or you see like Trinidad and Tobago, just think crown, right? Thus, the crown and corporations aggregate can be trustees, and personality can be held in trust. Provisions is made by the Municipal Corporations Act of 1882 for the administration of charitable and special trusts by municipal corporations. Charitable, public, special trusts, private. There are certain persons who, for obvious reasons, even if not legally disqualified, ought not to be appointed trustees. Such are infants, lunatics, persons domiciled abroad, felons, bankrupts, and seteki trustent. All right, let's see what seteki trustent means. Seteki trusted. Seteki trusted. Right. Sesteki v. Sesteke use. Seteki trust. Alright. Seteki trust. One who possesses equitable rights in property, receiving the rent, issues, and profits from it. Beneficiary, also term Fide commissari. Fide commissarius. Plural or public law. Seteki trust, or erroneously Seteki trusted. So plural, Seteki trust, or public law, Seteki trusted, or erroneously Seteki trusted. So Seteki trusted is plural, meaning more than one beneficiary, or Seteki trust meaning one beneficiary, or Seteki trust meaning beneficiary, and Seteki trust meaning beneficiary, or meaning multiple beneficiaries. All right. So Seteki trusted beneficiary. Now the reason why they're stating here that um such persons are disqualified ought not to be appointed trustees. In this case, the only thing I could think about is the doctrine of merger, where if you have one trustee in a trust, you don't have a trust because the trustee cannot be the trustee cannot be both beneficiary and trustee. But I digress. So we'll just leave it as is, as such as in funds takes persons of domicile abroad, felons, bankrupts, and Seteki trusteds. The appointment of any such person or the falling of any existing trustee into such a position is generally ground for application to the court for appointment of a new trustee in his place. So yeah, I think in this case with the Seteki trusted, it's due to having the beneficiary and the trustee hold the same position. Doctrine of mergers kicks in, and they have the legal title and the equitable title being vested in the same individual, thus terminating the trust. And that's why, in that case, a resulting trust will be created in the beneficiary or the Seteki trusted, and they will have to make an application to the court to get a trustee appointed. So in this case, I think that is what they are alluding to. Anyone may be a Seteki trust. So anyone may be a beneficiary, except a corporation aggregate, which cannot be a Seteki trust of real estate without a license from the state, from the crown, from the country, Trinidad and Tobago. For the public trustee, see below. Creation and extinction of the trust. A trust may be created either by act of a party or by operation of law. Where a trust is created by act of a party, the creation at common law need not be in writing. The Statute of Frauds altered the common law by enacting that all declarations or creations of trusts or confidences of any lands, tenements, or hereditaments shall be manifested and proved by some writing, signed by the party who is by law enabled to declare such trust, or by his last will in writing, or else they shall be utterly void and of none effect. Trust arising or resulting by implication or construction of law are accepted, and it has been held that the statute applies only to real estate and chattels real, so that a trust of personal chattels may still be declared by parole. The declaration of a trust by the crown must be by letters patent. All right, and this word here, parole, means by word of mouth. Parole by word of mouth. Trusts created by will must conform to the requirements of the Will Act. See will. Except in the case of charitable trusts, the Seteki trust must be a definite person. So except in the case of charitable trusts, so except in public trusts, The Seteki trust must be a definite person, and in today's day, this is the beneficiary principle. So when we go through the when we go through the study on trust in the Caribbean, we'll come across the beneficiary principle. So in a public charitable trust, the beneficiary need not be a definite person, but in a private trust, the Seteki trust must be a definite person and falls under one of the certainties. We'll get into that when we go through the study on trust. A trust, for instance, merely for keeping up family tombs is void. Alteration of the trust estate by appointment of a new trustee could, up to 1860, only be made where the instrument creating the trust gave it power to so appoint, or by order of the Court of Chancery. But now, by Section 10 of the Trustee Act, 1893, superseding Lord Leonard's Act of 1860 and the Conveyancing Act of 1881, the surviving or continuing trustee or trustees or the personal representative of the last surviving or continuing trustee may nominate in writing a new trustee or new trustees. On such appointment, the number of trustees may be increased. Existing trustees may, by deed, consent to the discharge of a trustee wishing to retire. Trust property may be vested in new or continuing trustees by a simple declaration to that effect. Also, a separate set of trustees may be appointed for any part of the property held on distinct trusts. Trusts created by operation of law are those which are the effect of the application of rules of equity. They include resulting and constructive trusts. Just that one of the rules of equity is a trust shall not fail for want of a trustee, right? In the case of a resulting trust, if a settler creates a trust and appoints a trustee, and the trustee disclaims the trust, the resulting trust principle kicks in, where the property reverts back to the settler, but the settler is now holding the property in trust. So that's how the resulting trust occurs. And in the constructive trust is equity regards as one of the principles is equity regards as done what ought to be done. And with the constructive trust is an equitable remedy where, say for instance, you go to a shop, you make a purchase of, let's say, you buy a biscuit for let's say $5, and you give the shopkeeper $10, and he give you back $15 change. You, in your consciousness, know you're supposed to get $5 change. The shopkeeper made an error and he gave you $10 extra. You will be considered a constructive trustee of that $10. So that is how a constructive trust is created, where it can be used for remedial purposes or for relief in equity. Well, we won't go in too much into that in this, as this read is just for learning the history and how the trust came about and things like that. All right. So a resultant trust is a species of implied trust and consists of so much of the equitable interest as is undisposed of by the instrument creating the trust, which is said to result to the creator and his representatives. All right? Resulting to the creator and his representative. An example is the purchase of an estate in the name of the purchaser and others, or of others only. Here, the beneficial interest is the purchaser's. An example of a constructive trust is a renewal of a lease by a trustee in his own name, where the trustee is held to be constructively a trustee for those interested in the beneficial term. Besides being duly created, it is necessary for the validity of the trust that it should be a lawful one. An unlawful trust is one which contravenes the policy of the law in any respect. Examples of such trusts are trusts for a corporation without license, for a perpetuity, and for purposes subversive of morality, such as trusts for illegitimate children to be hereafter born. Superstitious uses also fall under this head. There are also certain trusts which are avoided by statute under particular circumstances, such as settlements in fraud of creditors. See bankruptcy. The law cannot be evaded by attempting to constitute a secret trust for an unlawful purpose. If an estate be devised by words prima facie carrying the beneficial interest, with an understanding that the devisee will hold the estate in trust for such a purpose, he may be compelled to answer as to the secret trust, and on acknowledgment or proof of it, there will be a resultant trust to the heir at law. In the case of an advowson suspected to be held for the benefit of a Roman Catholic patron, there is a special enactment to the same effect. Si quaere impedit. The rules of equity in charitable trusts are less strict than those adopted in private trusts. The rules of equity in charitable trusts and public trusts are less strict than those adopted by private trusts. Public trusts are governed under statutes. Private trusts are governed under consciousness, chancery courts, equity. We'll get into that, all right? So charitable trusts must be lawful. Example, they must not contravene the statutes of mortmain. But a wider latitude of construction is allowed in order to carry out the intentions of the founder, and they will not be allowed to fail for want or uncertainty of objects to be benefited. The court, applying the doctrine of cypress or cypre, will, on failure of the original ground of the charity, apply the funds as nearly as possible in the same manner. On this principle, gifts originally made for purely charitable purposes have been extended to educational purposes. Further, trustees of a charity may act by a majority, but ordinary trustees cannot, by the act of a majority, unless specially empowered so to do, bind a dissenting minority or the trust property. A trust estate is subject as far as possible to the rules of law applicable to a legal estate of a corresponding nature. In pursuance of the maxim, equity follows the law. Thus, trust property is assets for payment of debts, may be taken in execution, passes to creditors in bankruptcy, and is subject to dower and courtesy, to the rules against perpetuities, and to the statutes of limitation. All right? So that's a heavy, this was a heavy sentence here. Heavy. So thus, trust property is assets for payment of debts, may be taken in execution, passes to the creditors in bankruptcy, and is subject to dower and courtesy, to the rules against perpetuities, and to the statutes of limitation. This assimilation of the legal and equitable estates has been produced partly by judicial decisions, partly by legislation. This assimilation of legal and equitable estates has been produced partly by judicial decisions and partly by legislation. Partly by judicial decisions, court cases, matters that came before the court, partly by legislation, acts and statutes. A trust is extinguished as it is created either by act of party or by operation of law. So if the trust was created for a purpose, and the purpose was to satisfy a debt, like in the case of the creditors in bankruptcy, the trust is extinguished upon the fulfillment of the purpose of the trust. And then by operation of law is, if a trust is created and is found that the equitable title is in the same person, trustee and beneficiary being the same person, you don't have a trust. The trust is extinguished immediately. It's called a doctrinal merger. So an example of the former mode of extinction is a release by deed, the general means of discharge of a trustee when the purposes of the trust has been accomplished. See? So the purpose of the trust is accomplished. Extinction by operation of law takes place when there is a failure of the objects of the trust. Example, if the Seteki trust die intestate without heirs or next of kin, the property by the Intestate Estate Act 1884 escheats in the same manner as if it were a legal estate in corporal hereditaments. Equitable interests in real estate abroad are as a rule subject to the lex loci re cite, and an English court has no jurisdiction to enforce a trust or settle a scheme for the administration of a charity in a foreign country. An English court has, however, jurisdiction to administer the trust of a will as to the whole real and personal estate of a testator, even though only a very small part of the estate and that wholly personal is in England. This was decided by the House of Lords in a well-known case in 1883, Ewing versus Orr-Ewing, LR 9 AC 34. So rights and duties of trustees, we'll take up that in the next video. I just want to go back to this little sentence here, this little area right here, and just pull some definitions from this just to make it a little more clear for us. All right. So thus, trust property. So trust property, that's the property of the trust, the rest of the trust, is assets. Any property in the trust is assets to the trust. And if the assets is for the payment of debts, it may be taken in execution. So the trust can be executed for the payment of debts. And the trust property can be placed in trust where the trustees now have the responsibility and the duty to sell the property, to invest the property, as the case may be, for the payment of debts. And it could pass the creditors in bankruptcy. So if there is money being owed to creditors, the trust assets could pass to the creditors in bankruptcy, and it's subject to dower and courtesy. So I just want to pull the definition of dower and courtesy so you can see the definition of dower and courtesy. All right, we're already in C, so let's just pull the definition of courtesy so you'll see. Courtesy. At common law, a husband's right upon his wife's debt to a life estate in the land that his wife owned during their marriage. So that's courtesy. At common law, a husband's right upon his wife's debt to a life estate in the land that his wife owned during their marriage. That's courtesy. All right. So let's look up dower and courtesy. If courtesy is the husband's rights and they use courtesy and dower, let's see. Maybe dower is the wife's rights. Right? Dower. So courtesy is a husband's rights to his wife's property after death. Let me see what dower is. Dower. At common law, a wife's right upon her husband's death to a life estate, right, in 1/3 of the land that he owned in fee. Right, so dower is the wife's right. Courtesy is the husband's right. Okay? So thus trust property is assets for payment of debts, may be taken in execution, passes to the creditors in bankruptcy, and is subject to dower and courtesy. To the rules against perpetuities. The rules against perpetuities is that a trust cannot be established for ever without a termination date. So let's see the rules against perpetuities, right? The rules against perpetuities are right. Rule rule against perpetuities. Right. Rule against perpetuities. So the rule against perpetuities property. The common law rule prohibiting a grant of an estate unless the interest must vest, if at all, no later than 21 years, plus a period of gestation to cover a posthumous birth after the death of some person alive when the interest was created. So the rule against perpetuities is a rule prohibiting a grant of an estate, right? No later than 21 years. So you could grant the estate for 21 years. After 21 years, the rule of perpetuities kicks in. All right. And so that's the rule against perpetuities and the statutes of limitation. So let's check out the statutes of limitation. This is very important for the comprehension while reading, right? And is definitions that we're gonna pull out all those words. We're gonna pull out all those words and we're gonna get the definition for them, and we're gonna make a glossary of all those words with those definitions. So we can have those words and definitions in front of us as we go forward in understanding, comprehending, and the study of trust and estates. Statutes of limitation, statute of limitations. A law that bars claims after a specified period. So the statute of limitations, if something happens, you have a certain time to make a claim. Where some wrong is done to you, you have a certain time to make a claim. If you don't make the claim within that time period, the statute of limitation kicks in. So a law that bars claims after a specified period. A statute establishing a time limit for suing in civil case based on the date when the claim accrued, as when the injury occurred or was discovered. The purpose of such a statute is to require diligent prosecution to known claims, thereby providing finality and predictability in legal affairs, and ensuring that claims will be resolved while evidence is reasonably available and fresh. Also termed non-claim statute, limitations period. All right? So that's the statute of limitation. All right? So the trust property is assets for payment of debts, may be taken in execution, passes to creditors in bankruptcy, and is subject to dower, the wife's right, courtesy, the husband's right, to the rules against perpetuities, not more than 21 years, and to the statute of limitations, where you have a certain period to make a claim, right? So the trust property, the assets for the payment of debt may be taken in execution, passes to the creditor in bankruptcy, but all this the trust property and the assets and pass to the creditor in bankruptcy is subject to dower courtesy, the rule against perpetuities, and statutes of limitation. All right, and this is one of the is a key fundamental of trust that we must comprehend and we must understand. This is how we be responsible for our actions and be responsible for our life and the way we operate in society with our brothers and sisters. All right. All right, guys. So we're gonna take up from rights and duties of the trustee on the next recording, on the next video. Thanks for your time and your patience. Remember, we boomerang in the mind. We pull in the mind back in the past and then slingshotting the mind forward. So we pull in the mind back into the past and pick up all the knowledge from the past and then slingshot the mind back into the present and observe from a different viewpoint, observe from a different comprehension, and start to operate totally different and the correct way we're supposed to be operating in society. So strength and powers, strength in body, powers in mind. Stay up.